Hello and welcome to Dialogue, coming to you from Beijing on CCTV News. I'm your host, Tian Wei. A 38-year-old man named Nian Bing recently walked free from prison after 8 years behind bars. He was acquitted of poisoning charges due to insufficient evidence, despite previously having been sentenced to death 4 times. His acquittal case is one of several widely publicized cases since China's Supreme People's Court began reviewing all death penalty rulings in the year 2007. However, many have pointed out the enormous problems still existing in China's judicial justice system, as reflected by Nian's case. For one, he was sentenced to death based on confessions obtained through torture. Additionally, there were obvious mistakes and loopholes that previous judges assigned to his case openly ignored. So, how should we understand the significance of yet another overturned judgment? Is it a rare exception to the rule, or does Nian's case represent ever stronger efforts for judicial justice in China? Will the recent policy on judicial reform move the country toward a better justice system? And how far, really, will it go? Joining us to answer all of these quite tough questions, I'm joined here in the studio by Mr. Wang Chengguang, who is professor with the Law School at Tsinghua University.
Hello.
Professor Wang, welcome to our program.
Thank you.
Also in our studio, Edward Lehman, Managing Director of Lehman, Lee & Xu. That's a law firm based here in Beijing. Gentlemen, welcome to our program. Before we go to a discussion with the both of you, let's take a look at this background report.
A Chinese court recently acquitted a death row inmate convicted of murder. In 2006, a grocery shop owner named Nian Bin was accused of poisoning his fellow villagers in Fuzhou's Pingtan County. 2 children died. Nian was sentenced to death in 2006. Following 3 appeals and 3 retrials with the same judgment, he was finally acquitted in August. Nian spent 8 years behind bars. In his previous trials, the court ruled that the facts were unclear and the evidence insufficient. After his acquittal, Nian was immediately freed, with lawyers saying that his earlier confession was obtained under torture.
The fact that this went to the Supreme People's Court was very important in this case. If the lower ruling had stood, Nian Bing would have died. Because the Fuzhou High Court did rule for a death sentence at the previous retrial, so that could have been the final judgment.
The Supreme People's Court began reviewing all death penalty rulings in January 2007. Ending a 24-year period in which the lower courts had full power to issue death sentences and execute criminals without the approval of the Supreme Court. There have been other erroneous judgments. For example, She Xianglin was accused of killing his mentally ill wife, who disappeared in 1994. He was imprisoned from 1998 until 2005, when his wife suddenly returned home from another province. He was promptly acquitted and received compensation for the time he had spent in prison. A new criminal procedure law issued in 2013 has also helped courts make fairer, more humane decisions. Additionally, judges have been advised that they should presume defendants are innocent until proven guilty. Injustices still happen, and the risk of wrongfully penalizing an innocent person is ever present. But progress is clearly being made in Chinese judicial reform, and Nian's case is a major milestone. Further, there is no doubt that guaranteeing sanctity of law and judicial independence will do much to improve China's legal system.
Professor Wang Chengguang and also Mr. Edward Lehman, welcome to Dialogue.
Thank you.
This case, after Mr. Nian serving 8 years already in prison, one could probably imagine how much that means for one individual and his family. He finally was freed. And this is one of those cases highly publicized in China. Professor Wang, given your knowledge of China's judicial reform, how significant is this individual case?
Well, this case is certainly one of the rare cases in which the defendant actually got acquittal judgment. This, of course, is very rare, and the rareness actually indicates the significance of the judicial system, particularly the reform of the judicial system, which is on the way for future. So in this regard, I think certainly this case is quite significant, indicates the further moves of the judicial reform.
Mr. Lehman?
Yeah, I think it signals hope. I think that there's hope. I think that there's hope and there's fairness and there's justice. And it's a combination of things. I think you need a good judiciary. I think you've got to have a very proactive criminal bar, lawyers that are willing to step in and do this, and people who have the courage to be able to change their mind and make a decision. That's what's most difficult, whether it's in China or another country.
This is a very rare case because, as both of you mentioned, this is a lot of zigzagging and back and forth. We need to brief our viewers a little bit, even though we touched on it in our backgrounder. First of all, he was sentenced to death based on his self-confession, which later found out was coerced confession. He was sentenced to death by the Fuzhou local court, intermediate court. Correct. And then he appealed. Then the Fujian Provincial High Court pushed this case back for retrial. But then the immediate court came up with the same death sentence. This guy and his lawyers made another appeal, and this case moved on to the Supreme Court. The Supreme Court pushed this case back and say, you guys better work on this case again. Same conclusion was reached by the local courts. And then he did it again, another repeal. Only then, two separate courts were being established, inviting the investigators as well as the forensic scientists coming over to let them testify. Only after those two courts that this man has been sentenced free from death sentence and also be free from prison. Mr. Lehman, can you help us to understand how many men would be as lucky and unfortunate all at the same time as this man?
Yeah, I mean, it's remarkable. It's a remarkable case, and like I said, it's a remarkable case of hope. It's a remarkable case that there can be
starting from the year 2007.
Right, that's right. And I mean, and actually with the year 2007, which coincided with the judicial review of death penalty cases, because at least the Chinese government was insightful enough at that point in time to say, hey, some of these things that are done at the local level, the city level, and the provincial level are probably not as good as they could be done by reviewing in the Supreme Court. So he was at the right place, wrong place at the wrong time by getting involved in this case. But that there were people that actually changed their minds is quite remarkable.
Yeah.
Normally, the inertia begins. You know, the police are looking to convict. I mean, and I'm not talking about in China, but in any jurisdiction, they want to find a swift conclusion, and they want to give peace to the persons who were harmed or the family that was harmed. And so that's what brings about this torture. That's what brings about these confessions. But does it help for law? Probably not. Does it help to make them look good as police if they found something? Probably.
So, Professor Wang, what do you think? You talk about the awareness of this case. How many would be as fortunate as he is, Mr. Nian is? I mean, after being sentenced to death, which was unfortunate to begin with, but still in time to catch up with the Supreme People's Court reviewing of all death sentences coming from all provincial and local levels, and also very, very strong lawyers team pushing back all the time. One could imagine this guy will not be able to pay handsome amount of lawyers' fees, but this is such a rare case. But does it give us much hope as a result of this rarity?
I think the hope is always there, and particularly I think in this case we should put it back into the social environment, particularly into the background of the judicial reform, and which means that the judicial reform has been going forward while the case was tried at first by the local intermediate court.
Right.
And the Supreme People's Court actually tries to reduce the death penalty numbers and also tries to regain the power to review all the cases involving death penalty sentences.
We're going to talk about the relations between the local court provincial high court and also the Supreme People's Court, and to understand what might be the loopholes, what might be the chances of corruption within the system later. But let me just read through to you the number that I found out before coming into the studio. The acquittals in China actually is very rare to begin with. In the year 2013, in fact, 99.93% of the defendants were found guilty. That is official statistics. I'm not saying, first of all, that those that are sentenced to death sentence or those that have been accused and sentenced to prison are not justified. But when one looking at this number, another question mark also arises.
Right. No, I think it does. I mean, in the year 2012, my understanding that the statistics were 100%. So it's down. It's actually down. And so our viewers can
0.03%.
Right. I mean, and I guess that's marked improvement. But I think that the point is, and it goes back to education to a certain extent, and it goes back to resources to a certain extent. The laws, when people are learning things in law schools in China today, a lot of it is rote memorization. A lot of it is not necessarily teaching people to be advocates. I mean, I think these lawyers were extraordinary in Fujian province, that they actually were advocating. I think that there's a tendency to listen to authority here, say, okay, we've got a one-party system and to carry on, and that these people had courage to be able to do that was really out of the norm. And I think that now the education is changing, and I think the judiciary is changing, and so there is some positive hope. The numbers are bleak, for sure. I mean,
the education part of it certainly is very much related to the qualities of judges and also the investigators, the police, and also has a lot to do with the eventual result. We're going to also look at that in a while. But Professor Wang, when you look at this number, 99.93%, is it normal?
Well, this is the kind of typical Chinese practice. In the old days, and even in the recent years, the acquittal ratio is very low. And that indicates not only the education, but also education certainly is one of the important factor. And there are several other factors. Another one I would like to say is actually the legal or judicial culture. So for judges, in their practice, they have a kind of fixed mindset, which indicates if they acquit the defendant in the cases they're handling, and possibly they will subject to criticism or by their superior, by the media, etc. So it's a kind of tradition or kind of mindset, and which firmly rooted in their minds that they must punish the defendants rather than to go through the fair procedure to acquit them. So this is a kind of, I would say, very old, deeply rooted
to rather sacrifice an innocent man's life when trying to save the face.
Yeah. It's a kind of a wrong conception in the judges' minds, and this conception is created not only by the individual judges, but also created by the system, by the legal environment. And if you look at the society, there are media outcries whenever there's a case, try to find out and nail the defendant down and punish the person. So this is the kind of culture pressure on the judges, and therefore the kind of trying to find the criminals, and even though in their case the defendants may or may not be, but there's a kind of tendency they try to catch the person.
Exactly, and therefore, when you think about the other way around, the High Court of Fujian Province should really be congratulated because they turned back this death sentence case several times to the local immediate court, and also it has been very strong in turning back or acquit this specific case.
And also, I would like to say the Supreme Court actually played quite a significant role to recollect the power to review the death penalty cases, and also clearly send out the signal, try to reduce the death penalty number. and trying to find the case on the basis of the evidence.
But even to go to Professor Wang, what he was saying and what you were saying before, Tianwei, is that this whole thing is a knock-on effect. I mean, because we have clients that have been involved and have got caught up in white-collar crime, and so we understand. So the police make an arrest. Within 7 days, they don't have plea bargaining here. Within 7 days, and I'm just sort of giving it a general overview, they have the ability to give some charges. Once this arrest is made, you almost are in the system, and then they've got an investigation that goes on for 45 days or whatever that term is. Then it goes up to the supervisor and the police. Then it goes to the prosecutor, and then they do their investigation. What I'm saying is, once you're in this very involved system, it's like Professor Wang was saying, you're saying before, Tianwei, to have the courage to say, you know what, maybe we don't have enough evidence. Nobody wants to do that. They're already in there. People have already put their necks in the line.
So the fundamental principle, gentlemen, is very important here. Whether a person is already guilty until proved innocent, or innocent until proved guilty, the fundamental principle that should be enshrined in the judicial system that we have here in China is a question mark, and that question mark is going to be explained to you later in our program. Meanwhile, how will the current ongoing judicial justice reform in China, which has been raised, specific plans in the month of July, just recently, going to change the overall picture? To what degree and how much still needs to be done? You're going to supposed to answer those questions, very tough ones, right after this break. We'll be right back. Welcome back. You're watching Dialogue on CCTV News. We are talking about China's judicial reform today with an acquittal case recently. With me in the studio once again we have Edward Lehman, who is the managing director of Lehman, Li and Xu. That's a law firm based here in China, and also Professor Wang Chengguang, professor with the Law School of Tsinghua University. Gentlemen, earlier you've been helping us to analyze the details of this acquittal case of Mr. Nian, who recently been released from prison after serving 8 years there, and in fact he was being found innocent, or at least there's not enough evidence to show he is guilty. But some suggest, Mr. Lehman, that the real test of China's judicial justice is going to be what happened later, after this acquittal, because people are looking at whether those police officers who tortured Mr. Nian for the coerced confession are actually going to be found guilty. Meanwhile, the real criminal for that specific case he was wrongfully accused of are going to be caught. And also, whether the culture inside our judicial system is likely to be changed as a result of this very interesting and certainly tragic case. Do you agree with these opinions? And secondly, what to you is the hope here?
Yeah, I think I agree with you that, this is a point that's going to come up, which is the police officers and the people who coerced and the state that might have participated in some way, shape, or form. They should be held civilly or criminally liable for those damages to this individual. At least that's the way we view it in the United States, and I think that China will probably take a look at that as well. This is the man's liberty for 8 years. Right. This is his reputation. This is his family, his right to earn a living. So I believe that that's the next step, and that should be something that should be looked at. And it's not only against those particular people, but it's a message to all people not to do torture. It's a message to all people not to take the evidence lightly and examine that. So I think that that's very important. And it's an important next step, and we should all watch to see what happens.
Right. Punish one is easy. For example, those police officers who are probably responsible for the coerced confession. But to create a culture is an extremely tough task. Professor Wang.
Yeah, this is a very good point. If you change the entire operation of the system, and particularly change the culture of the judiciary, is more challenging, because the mindset of the current judges must be liberated, must be created to some sense. I think this is more challenging work, and just imagine, like Mr. Lehman already described, once the suspect was caught, was already put into the machine.
Right.
The machine operates according to its own logics, according to its own a kind of fixed format. And it's very difficult for one person, one part of the system to stop it. And unless the system guarantees either the police, prosecutors, or judges, they can stop the operation of the machine.
All right, let me ask you whether this is going to stop the ill logic, at least ill parts of the logic existing in our judicial system. We understand in the month of July, the Chinese government is already talking about a blueprint for China's judicial justice reform. And it's been put out to do several things. And may I just read out these because these are quite abstract concepts. Quote, China's judicial reforms are aimed at strengthening judicial organs' capabilities to maintain social justice by optimizing the structure of the judicial organs and the allocation of their functions and power, standardizing judicial acts, improving judicial proceedings, and enhancing judicial democracy and legal supervision. This is actually coming from the white paper related to China's judicial reform. These are very abstract concepts, so let me just ask you specifically. Now, in the July plan, there is something called the judicial selection committees that are likely to be established at provincial level. The point of it is, as argued by the government, is that it's going to avoid the local government, meaning the governments lower than the provincial government, to appoint judges at their levels, which are they consider as favorable to their cause, and therefore avoid the potential of corruption. Is this likely to work?
Well, this is a very good idea. First of all, I agree with this kind of proposal. And first of all, it will keep away those who have no any professional or legal background from being sitting in the bench. And secondly, it will give the power to the provincial level, trying to get rid of the so-called local protectionism by the lower government and lower courts.
But here's the interesting thing, Mr. Lehman. So who are likely going to be the members of those judiciary selection committee? Isn't that a question to ask?
Oh, yeah. I mean, the implementation, I mean, those are beautiful words. And the concept, I couldn't agree with more. The question is with implementation. I guess we have a saying in English, there's two things you don't want to see made, sausage and law. And I guess one of this policy in and of itself, I mean, it's going to be very difficult to make an implementation that's going to work across a very large country. With
in the U.S., you also have this federal judge selection committee.
We do.
So how does that work, and how do you think those lessons and experiences can be learned by China, even though China is having its own judicial system, of course?
Yeah, and I think in America it's been an ongoing process. I mean, a lot of times they're appointed by senators, there is a judicial committee that's done on a federal level for federal judges, which they're a higher standard, and they're reviewed by the Congress, and they're actually appointed by the president for life. These federal judges, the salaries are higher. That's something that they could look at as well here in China, and to
avoid any potential of corruption.
Correct. And then there's also judicial review where they can pull, if these people prove to be not sane or make decisions that are not good, they could possibly be pulled as judges.
But that's federal judges.
That's federal judges, right. Then the local judges, it's a bit of a mess just like in China. I mean, so we have issues. We have, even where I come from in Chicago, judges are elected, which is very, very strange.
All right. Interesting. Now, how do those points explained by Mr. Lehman can be lessons and experiences for us? And meanwhile, Professor Wang, why provincial level? What do you make of this level, first of all? And secondly, what should be the ideal makeup of those members in the so-called judicial selection committee to make our judicial justice reform correct and also sustainable?
Well, this very idea is actually introduced from the American experience, and which had actually raised a long time ago when China drafted its law of judges. This idea to form a kind of committee for selecting judges was proposed. But I'm very glad to see now the proposal long time ago is going to be implemented pretty soon. So
but how
first
to
of
implement,
all,
that's an
how to
important
implement it is actually the real question for this plan. And first of all, I think the components of the committee, who are the members of this committee, they should not only from the current bench, the judges, but also should be from the defense bar, the lawyers, and also from the common people, the lay persons. So it should be a mixed up committee.
And also provincial level. That's an interesting level to be chosen.
Provincial level is more higher than the county level, therefore they will not consider the local interest. I think this is a very point for implementing it at first at the provincial level, because all the judges should have the same quality rather than different qualities by different level of the government.
When you said at first at provincial level, certainly that is a phrase that you use worth thought-provoking in a way. Let's go to another point about this judicial justice reform in China. Very important piece of reform for China's overall political reform. The other thing it talk about is Judiciary Council. Usually, at this moment still, the judge on the cases are not necessarily going to make the final decision, but rather the decision is being made by the Judiciary Council. And in the future, according to this reform plan, some of the judges, in certain cases, going to make the final decision. But in certain cases, it's going to be a mixture of the decision between the Judiciary Council and also the judge. So how does that work? How that would help us to reduce some of the corruption potentials inside our judicial system, Professor?
Judicial Council or Judicial Committee is a kind of organ within each court. It's composed by the experienced judges and also judges holding some higher level as administrators, such as the president, vice president, etc. So it has a kind of function to review all the difficult cases or complicated cases. That means most of the cases will be handled independently by the panels, by the judges, unless the cases are very much difficult and some difficult legal issues or factual issues, and then the case should be raised by the panel or the presiding judge to the committee. But in practice, sometimes the committee voluntarily initiate to take the case into their own hands.
So this should be changed.
There should be a change.
There should be
Most
a change
of the
about
cases
this.
should be decided by the panels and judges.
Right. Well, this is a very complete picture. We're talking about judicial justice reform in China. It would take years to perfect it, but we have to start from somewhere. And this specific case is certainly giving us hope. Where is the hope? Final words from you.
The hope is that they're making these changes in July, and we've got a chance.
All right, Professor Wang, final word from you.
I think it is the ice-breaking case, and it indicates the further steps very much urgent and necessary.
All right, we're looking forward to the reform steps, and certainly we want to congratulate Mr. Nie after serving 8 years in prison. Finally, his tragedy is being known and justice is being served. Thank you so much for both of you for coming over to our studio, Professor Wang Chengguang and also Mr. Edward Lehman. Thank you very much, gentlemen, for being with us.
Thank you.
And thank you for watching. I'm Tian Wei in Beijing.